So, for the third time, the Supreme Court overruled the way the President, and this time overruled the way Congress, have been dealing with suspected terrorists, saying that they have a constitutional right to challenge their detention before a federal judge. Mr. Justice Hume, do you concur or dissent?
I dissent, and strongly, on a couple of grounds. One is that the distinction that the court made to allow itself to make this ruling was that Guantanamo, although the court acknowledged that legally it is not under the control of the United States, one would think these fellows being judges, men and women being judges, they would legally would be what was most important. They then said, however, as a matter of fact, Guantanamo is really under full American control. That could be said, Chris, of any American military installation anywhere in the world. We control those places. We control them with our forces. They are, in effect, American territory. So the writ that comes out of this opinion could run in many, many directions, and who knows where it will stop. The court insisted that this applies only to Guantanamo, but by its own reasoning, it most certainly would not. Secondly, the court, in an earlier decision in this line of cases, had told the President and Congress that they needed to come up with a system to safeguard the legal rights of these special defendants, these special captives, not yet defendants. The Congress and the President did precisely that. That system has just been put in place. It is only yet beginning to work, and the court threw it aside without almost without discussion as being somehow inadequate. It did not then call upon the President and Congress to come up with a new system. No, it simply said, well, everybody has access to the American courts as if they were American citizens. The reasoning is almost breathtakingly flimsy.
Well, whether it's flimsy or not, Mara, let's look at some of the opinions from the court. Writing for the 5-4 majority, Justice Kennedy said, the laws and Constitution are designed to survive and remain in force in extraordinary times. Liberty and security can be reconciled. But here's Justice Scalia's dissent. The game of bait and switch that today's opinion plays upon the nation's commander-in-chief will make the war harder on us. It will almost certainly cause more Americans to be killed. Can't get much sharper in difference than that.
No, and that remains to be seen. But what Kennedy is saying is go back to the drawing boards and figure out something where you can try these people and still have them have the basic rights of habeas corpus. They can challenge their detention before a federal judge. Whether you're going to actually try them in exactly the same way as American citizens would remains to be seen. But this does mean that the administration does have to go back to the drawing board. Both candidates who are running for president say they were going to close Guantanamo anyway, so that's going to happen no matter what. Where exactly these prisoners are going to go and what you're going to do with them is unclear. They're not considered POWs according to the Roberts Court.
This is going to have immediate implications. Well, first of all, I hope Senator McCain, when he becomes president, appoints Justice Hume to the Supreme Court. I think he's considerably superior to Justice Kennedy, I would say, based on his terse analysis here. Look, this is going to create chaos. I mean, Barack Obama, you showed the clip of him saying, well, all this means is that you get to go to a federal court and say it wasn't me or I didn't do it. Okay, so the terrorist who's held at Guantanamo says that. The government says, we have very good reason to believe it was him, and he did do it based on intelligence provided that we acquired in one way or another. Then what does the federal judge do? Does he have an evidentiary hearing? Does he judge whether the CIA's intelligence was correct, that their informant in Karachi was telling the truth?
Yes.
Does he call the CIA agent in? The CIA agent comes into court and says, I got it from an informant.
Not a trial as to whether or not the person's guilty, but whether or not they have right to detain him.
But in fact, habeas is almost all the time, habeas challenges after a trial when there's new evidence or there's something wrong with the man's detention, and they go to federal court and say, wait a second, we now know something we didn't know, or this guy's being detained incorrectly prior to trial. That's based on established case law and statutes. This is a totally uncharted waters. It's utterly unmanageable. And I think what it means is Congress has to step in now and specify, okay, if the court's going to make us do this, we need to set up a system of a national security court that can handle these trials. And this has been proposed by Andrew McCarthy, the former federal prosecutor who tried the blind sheikh in New York and has a very good book out on the problems of trying to do this through the federal legal system. Anyway, but you could do it. You could have a national security court. Senator Lindsey Graham is working on this, and I think you will see Senator Graham, accompanied by Senator McCain, come to the floor of the Senate very soon, like next week, and say, we cannot let chaos obtain here. We can't let 200 different federal district judges on their own whim call this CIA agent here, say, I don't believe this soldier here who said this guy was doing this. You have to release someone, or let's build up let's compromise sources and methods with a bunch of trials. I mean, it's ridiculous. So Congress has to act. Senator Graham and Senator McCain are going to insist on action. It will be interesting to see what Senator Obama's response is if the serious legislative proposal is introduced to set up a way of doing this consistent with the Supreme Court decision.
Well, I'm glad to hear you say that, because I think what you're saying is you're agreeing basically with the 5-4 decision, because you're saying there needs to be a structure, that you can't simply hold people for an undetermined length. And remember, this Guantanamo's been open 6 years. 6 years without resolving this. And they've only had plans to try, I think it's 80 of the 270, and only 19 currently face any kind of court, have the opportunity to speak out and say, you know what, it wasn't me that did it, or I was caught in the wrong way. And the military courts have said that occasionally they have swept up the wrong people. In fact, the named litigant in this case was someone who's taken from Bosnia, not from Iraq, not from Afghanistan, Bosnia. So he's trying to make the case that he was in the wrong place at the wrong time. So when you say, okay, let's have a national intelligence court, that's fine with me, but it seems to me that you are confirming, you're not agreeing with Brit Hume. You're saying, in fact, we need a structure that gives people the opportunity to come before the courts and say that I have been detained illegally and wrongfully. And that's a good thing. That's protecting America's rights and liberties, even in a time of terrorist war. Because remember, this is not the Civil War. This is not World War II. This is something that's going to go on for all time. We're going to be constantly fighting terrorists, and are we going to sacrifice our civil liberties for all time? I don't think we want to do that.
The supposedly governing precedent in this case goes back to World War II and Nazi soldiers who were held in detention in American-occupied Europe in a camp not dissimilar to Guantanamo, although not nearly as nice. The Supreme Court held at that time that it did not have the jurisdiction, and the American constitutional law did not apply there. The distinction they're making here, in order to allow the court to do what it was obviously bent on doing before it even heard the case, was that somehow Guantanamo is different from that American-occupied area in Europe after World War II. That is a pretty lame distinction. And moreover, Juan, you're talking about legal safeguards for these captives. The legal safeguards already in place for these captives are, or were, as Chief Justice Roberts pointed out, the most extensive and generous ever yet permitted for captured enemy combatants.
Wait a second. You're confusing your terms.
Let me just clarify my position, since you get just okay. Yeah. I just want to make clear. I think it was a very bad decision. A large part of me wishes that President Bush would stand up and say, as President Andrew Jackson said almost 200 years ago, you know, Justice Kennedy has made his decision. Let him enforce it. On the other hand, that's not going to happen, and there's a real practical problem now with potential chaos and release of either information that shouldn't be released or of terrorists who shouldn't be released, and that's why I think Congress has to act. Congress has to now do the right thing, but I very much agree with Brit. Congress tried to do the right thing before. There was a bait and switch by the Supreme Court. They've decided Congress didn't do the right thing, but Congress has to act aggressively now to prevent chaos in the federal courts.
But what I was saying to you, Bill, was you have to understand habeas corpus is put in place literally to restrain what could be the unlimited power of the executive here. You don't want the president deciding, gee, I don't like what Bill Kristol said the other day, put him in jail. No.
American citizens.
Come on.
American citizens have a right to habeas corpus, and anyone arrested in this country has a right to habeas corpus. But these are people arrested in Bosnia, as you said. And how is the federal judge going to decide whether the
that's what you said. Let's set up a structure, a process. And in fact, I think Justice Roberts was right to say, you know what? If you folks disagree with the current situation, you should outline exactly how you think it should be done. Instead, they have sent it back to the district courts.
We got less than a minute.
But just a second, let me just say to Brit.
No. Okay, I'm in charge here.
Fine. All right. I just wanted to respond.
One last question, because we have less than a minute left. With the Supreme Court now saying, and you don't agree with it, but you certainly agree that's what they're saying, Brit, that the Constitution does apply to Guantanamo Bay, does this really remove the last remaining rationale for keeping this facility open?
Well, possibly, but if it isn't this facility, it'll have to be something similar to it somewhere else, which would be outside of the reach of this court. So this kind of mischief and recklessness would not obtain. However,
well, the court doesn't seem to think there's anything that's outside.
That's exactly the point that I'm making here is the reasoning behind declaring Guantanamo within the court's jurisdiction and the application of habeas corpus to it would extend very far in many places around the world. So I am at a loss to be sure that you could close Guantanamo and solve the problem. I think that would not solve the problem.
but I'm not sure that putting it anyplace else is going to solve the problem either. We have to take a break here, but up next,